And we're back. And thanks for your patience. Once again, I'm here with Elise Griesmeyer. She's the supervising attorney for the Crime Victims Assistance Program at Catholic Charities Cabrini Center for Immigrant Legal Assistance here in Houston. In her work for Cabrini Center, she assists international victims of crimes, including human trafficking, domestic violence, and other serious crimes with U's, T's, and VAWA. Before joining Catholic Charities, she worked in private practice and criminal law, and Elise completed her JD in 2009 at U of H Law Center and received her BA from Notre Dame in 2005. Elise, thank you for joining us today.
Thank you.
We're here at the beautiful downtown Houston headquarters of CILA in the studio today to talk about remedies for immigrant victims of crimes. And we have a lot to cover. Like I said earlier, if you have any questions as we go through, please put those in the chat box, and we'll try to get to them in the moment or at the end if that's where they're more appropriately answered. So what are we going to cover today? Like I said a second ago, U, T, VAWA, and we're going to go through some special issues and practical steps for everybody who are working on these alphabet soup-like visas. The sources of law are here. We're going to send PDFs to everyone, and we'll have this available on our website as well, the recording itself and the materials. So you can refer back to a lot of these slides later for things like these sources of law. I'm going to start with U visas, and I want to turn it over to Elise to get us going. But before I do that, I just wanted to say that the whole idea behind this presentation today from CILA is that we want to encourage the legal service providers throughout Texas to look more closely at criminal issues with their cases and crime victims issues, especially alternative forms of relief from what are normally the primary forms of relief in UAC matters, SIJ or asylum. Obviously, in a different climate now, we need to be looking at a broader kind of net of what options are out there. So as we go throughout, we're going to talk about the overarching qualifications and elements of all these things, and we're going to try to put a spin on it in the form of how does this relate to children, or what do you need to do to get at these forms of relief for child clients. Elise.
Thank you, Brandon, and thank you everyone for being here on a Friday afternoon. We're going to jump right into U visas and spend the bulk of our time here, as they are more common than T visas and VAWAs we found, but they are really flexible, really generous, really wonderful forms of relief, especially for clients with some pretty serious grounds of inadmissibility against them. So here on this first slide, we're going to go through the U visa requirements. First, that they're a victim of a designated crime that occurred in the United States or violated U.S. law. Second, that they had information about the crime and have been, are being, or are likely to be helpful in the investigation or prosecution of that designated crime. Number three, they suffered substantial physical or mental abuse as a result of the crime. And fourth, that they're admissible or eligible for a waiver. We have a whole section on waivers, which are generally the most complicated part of these cases. So we're going to go through that in depth. Next up, if you win a U visa case, there are certain benefits the client is eligible for. First, non-immigrant status for 4 years, employment authorization, and they and their derivative beneficiaries are eligible to apply for LPR status after 3 of 4 years of full U status, which we'll talk about in depth in a moment. Next, we're looking at the crimes that qualify. So a lot of the crimes that I've bolded here on this slide are crimes that we see a lot with our minor victims, and these are the more common ones we see overall as well with adults. So it includes, and I won't read them all to you, but it includes generally very violent crimes and sexual crimes, especially those perpetrated against children, but also includes trafficking, sexual exploitation, and kidnapping, a lot of what we see with recent border crossers.
Yeah, Elise, actually I wanted to ask you on that substantially similar language that we have underlined there, and what are some enumerated crimes for U visas that fall under similar activity in Texas that you find you have to explain?
Right. So as Brandon pointed out on the slide here, any of these enumerated crimes will work, but any violation of federal, state, or local law that's substantially similar to a qualifying crime can itself qualify. So one of the recent examples we have in Houston is a lot of crimes here that might be classified as aggravated or felonious assault under these qualifying crimes are actually charged or investigated as aggravated robbery. Even though aggravated robbery isn't listed on these crimes here, we argue that it's substantially similar enough to qualify for U visa purposes. There's also, just to point out, there's no requirement that the criminal activity be a felony or that it even reach the point of charge or of criminal trial or of a final verdict. As long as the victim has created some kind of report, that's usually enough to qualify for purposes of U visa.
Okay, great. Let's move on to this next piece here with the victims.
One point that I think a lot of people don't think about is the difference between direct and indirect victims. The U visa law is actually very generous when it comes to who qualifies as a victim. The first is direct victims, who we classically understand are victims of crime. It's the abused spouse or child. It's the victim of a sexual assault. However, direct victims can also include bystanders who suffer unusual direct injury as a result of the qualifying crime. It can also include indirect victims if the victim themselves was a victim of murder or manslaughter, or is incompetent or incapacitated as a result of the crime, or because of age. So what that looks like for a lot of our cases is if we have a minor U.S. citizen victim, their immediate family members, which means siblings under 18 and parents, could qualify as indirect victims based on the crime perpetrated against the minor. And I've listed out the classes of people that might qualify as indirect victims, and that's determined at the time of the crime, their ages at that moment.
Yeah, so when you say bystanders could qualify, my mind goes to like 1L torts law and something like intentional infliction of emotional distress. Is that basically what we're talking about here?
Basically, yes. So with the bystander victims, the classic example that people give is a shooter shoots into a crowd of people aiming for one specific person and kills that person. A woman standing nearby happens to be 8 months pregnant, is so shocked and traumatized by seeing this murder that she goes into early labor or miscarries, resulting in damage to her and to her child. She was not the intended victim of the crime, nor the classic victim of a crime, but suffered unusual direct injury as a result of the crime and could therefore potentially qualify for a U visa.
Interesting. And on the indirect victims, what's been your experience with getting minor siblings qualified as indirect victims?
Minor siblings aren't usually the kind of victims we see qualifying as indirect victims, normally because it's the parent doing the majority of the cooperation. So when we do see that, it's when sibling has taken over as the guardian of the minor. And generally speaking, other siblings under the age of 18 qualify as derivative beneficiaries of their parents who are cooperating. But it is theoretically possible. We've even seen it with some younger siblings, 16 or 17 years old.
Okay. And on to the law enforcement authorization.
This is generally the hardest part of starting a U visa is how do you even begin with law enforcement? The way to document your client's cooperation with law enforcement is a form called the I-918 Supplement B, which is required in order to submit an application for a U visa. There's, again, no requirement that the perpetrator be caught or arrested, but you do have to go through the certifying assistant of each law enforcement agency you work with in order to get the appropriate signature from that agency. And one note here, in italics in the first point, is if the victim is under the age of 16, the parent can be certified as having cooperated with the police.
Yeah, I think that first bullet point is important because in the screening process, a lot of times we often ask the child if they've ever spoke to the police about a matter, and they say no, so we discount a U visa as an option. So it's important to recognize that that is kind of a factor with that age limit at 16, and ask them if their parent, or ask the parent directly probably, if they've ever cooperated with law enforcement.
Right, and it's important to screen carefully. If you're looking for the benefit of the child, even if a parent has cooperated with police on behalf of the child may have no memory of that, but still might be able to benefit either as a principal or derivative of that criminal activity.
Great.
So, as I said, the hardest part is generally getting that law enforcement certification. So the first step is finding out what agencies could certify, and most large agencies already have a youth certification policy in place. If you're dealing with a smaller agency or a rural jurisdiction, you might have to educate them on what the U visa is. There's a lot of different ways to do that, but generally speaking, we send a copy of the certification form as well as any documents we have to law enforcement and wait for their response. They take anywhere from 2 weeks to 2 years to get back to us, and some will respond with a signed certification, but also then indicate that the victim was not cooperative during the process. Each law enforcement agency, and the qualifying agencies are police departments, district attorneys, and judges. They each have complete discretion to sign, to not sign, or to fill it out in any way that they choose. And with the exception of California, there's no municipal or state level laws in place to enforce their responsibility or in any promises they make to the victim themselves. So it really is relying on their discretion to sign these or not.
So in those instances where they will sign something but they say that the victim was uncooperative, do you have experience with working with an agency to appeal that decision or persuade them otherwise? How do the mechanisms work there?
There's no formal appeals process because it is ultimately within each agency's discretion. If you do have a good working relationship or feel very strongly about the client, you're welcome to get back in touch with that certifier to explain any mitigating circumstances, to explain further cooperation. But generally speaking, at least with the agencies we've worked with, once they've made up their mind, they've based it on their reports and the information they had, they're not very quick to change that.
And so with this agency policy, I know it can vary wildly. What are some examples of different organizations that have clear policies and some that don't even know what the certification is in the first place?
Right. So in smaller counties, for Liberty County, for example, or South Houston Police Department, they don't have any set policies that we're aware of. But for larger agencies that receive hundreds, if not thousands of these requests, they have set policies. So here in Houston, we know that the Harris County District Attorney's Office puts out information. They'll only sign certifications within 3 years from the date of sentencing. For the Houston Police Department, for example, it's 4 years from the date of report. And you can always try submitting outside those time frames, and subject to their discretion, they may or may not sign.
So is it safe to say most larger law enforcement agencies are going to have some kind of a policy in place?
Safe to say, and some of those are very time sensitive. So if you do find a case where a crime happened in 2013, 2012, it's important to submit those requests immediately in order not to lose the potential for a certification.
All right. And on a practical note, do you send your clients down to the law enforcement organization to get the certification, or do you handle that yourself?
No, that's something we handle ourselves. Our legal caseworkers request those certifications, and in fact, some agencies, the Harris County Sheriff's Office among them, won't sign certifications for pro se applicants, only for those with attorneys.
Wow, I didn't know that. All right, well, let's move to this final piece here on common problems.
Right, so this is often the hardest thing to explain to a client who might not get the intricacies of that discretionary decision made by law enforcement. Is first, a U visa case must be based on a criminal investigation or prosecution, though sometimes a protective order alone will qualify. Victims of a crime that wasn't reported for whatever reason won't be eligible. They can try to file a delayed report, especially for minors if they have a good reason, but then again, it's always up to the discretion of the agency. The qualifying crime for most purposes must have occurred in the United States, and a jurisdiction lies where the criminal activity occurred. And again, it's always discretionary. If the agency decides not to certify despite extensive cooperation by the victim who did everything in their power to do, if the agency at the end of the day says no, they say no, and the victim won't qualify for U status. And lastly, even if they're really a victim, if the client is implicated in the report, which we see a lot with domestic violence, they likely won't be eligible for the U visa because they won't be certified as a victim.
Okay. I want to touch on this aspect of the crime having occurred in the U.S. Many children, they can describe something happened to them, some criminal activity, but they can't tell you what side of the border they were on when this happened, right? So what do you do in that situation, or how do you deal with this type of jurisdictional or geographic uncertainty?
I think it's always best to err on the side of trying to make a delayed report and trying to find the best federal agency appropriate if you're not sure of the local jurisdiction. So if, for example, we're not sure if it happened in El Paso or Ciudad Juarez, you could still try to report to HSI, a federal agency, to see if they're able or willing to open an investigation into that activity. It won't always be successful, but it is worth a try.
Yeah, and I know I've also seen, cases that we've worked on where the scenario was Homeland Security Investigations was asked to do the certification, and it was based on a rape by the smuggler. So the smuggling itself was not enough, but the rape is what really got the criminal hook for the certification for HSI to get involved. And on the geographic and jurisdictional side, the petition was successful because the client statement said that she was raped at the place where she was rescued from.
Right.
And so they could at least prove that she was rescued from X place, and that was in the United States. They couldn't prove the rape took place there, but that was enough to allow HSI to go ahead and certify on those grounds.
Right, and it's always best to try to give them the information so they can try to make the determination that they do have jurisdictional power over it. But it is a difficult decision for them to make sometimes as well.
Okay.
So the next part of a U visa case is showing the applicant suffered substantial physical or mental abuse. So I've listed out some of the issues that USCIS will consider when making this determination, and I won't read them all to you, but I will say that they are a subjective standard. So they're looking at the point of view of the applicant. When you're dealing with minors then, one obviously relevant consideration is the victim's age. How being a victim of sexual assault or violence is different in your experience at 14 than it might be at 30 or 35. Regardless, it's a traumatic event, but your coping skills are lessened when you're young. But they will do that from a subjective standard. So next we're going to talk about who you can include in the U visa application for derivative family members. There are two general rules. It must be a qualifying family member of the principal at the time of filing, and they must be admissible or qualify for a waiver and themselves not culpable in the qualifying crime. So for adults, it's spouses and children under 21 and unmarried, and for minors, it's a much broader spectrum of people. So it's spouses, children under 21 and unmarried, unmarried siblings under 18, and parents or any and all of the above. And it's the age at the time of filing that controls. Derivatives outside the United States can come to the U.S. through consular processing only on final U approval, not through conditional, which might change in 2017, but we haven't seen any strides towards that. And at time of the adjustment, they'll have an opportunity to apply for any other family members using the I-929.
Okay. And that special rule for siblings, I just want to point out again that it's the age at the time of filing the 918 that controls, right?
Correct. So if you have a victim who's 15 years old and they have a sibling who's 17, you need to get that application submitted before the sibling turns 18.
Okay.
So I've referred to it several times, but there's multiple levels of U visa approvals because the TVPA limited principal applications to 10,000 per year. The current backlog is actually over 150,000 at this point of both principal and derivative applications. So if the client runs into this limit, which is almost guaranteed, when the decision is made by the officer, they'll first be put into conditional approval, which comes with deferred action and work authorization for principal and any derivatives in the United States, and full approval when that visa is available. They can also begin consular processing for derivatives, and they begin accruing time for adjustment. But almost all clients will go through that. We have a timeline on the next slide of what cases look like from start to finish. So a case begins with a screening. The attorney requests the certification, which can take from 2 weeks to 2 years. Then you go on to file the case through CIS, through conditional approval, full approval, then adjustment of status.
Yeah, and I'm sorry, I'm noticing the slides are a little bit off here. For some reason, there's a mistranslation when we put it into our webinar software. But we'll get everyone the PDFs of these slides that are on the call now, so we can get that out. And again, it'll be available on our website too.
So some of the recent trends we've seen in U visa cases are, the biggest issue is this processing time. They're so inundated with applications that the Vermont Service Center has been very backlogged. Current processing time just for a conditional approval is 2 to 3 years on average, which we anticipate is only going to get worse over the coming years. They recently began outsourcing cases to the Nebraska Service Center in the hopes of speeding that time up. And they've told us they're looking for some kind of parole for derivatives during conditional approval, but we haven't seen that yet. they recently, in January, updated the I-918 and, more importantly, the I-918B, the certification form. Those outdated forms can only be used until September 30th. So if you have a certification, even if you receive it right now, signed on an old form, it must be received before September 30th in order to use that certification.
And those certifications are only good for 6 months anyways, right?
6 months exactly.
So if you're getting it right now, well, it's too late, really, because it would already be expired by the end of September. So people should taken that into account.
Sure, absolutely.
And, I did want to ask you, on the derivative family members abroad are concerned with the conditional approvals. The update you said hasn't happened yet. Is there any reason to think that it might anytime soon?
Right. Well, as of the end of last year, they promised they would have something available to us. They said it would take the form of some kind of parole process, and they told us sometime in 2017, but they were not specific as to when, and we haven't heard anything since.
And so there is a process, however, with the T visa approvals where you can do the derivative consular processing.
Right, on T approval, yes.
On T approval, which comes a lot faster.
Exactly.
So speaking of T's, let's move into that.
Great. So here are the T visa requirements. The applicant is or has been a victim of a severe form of trafficking in persons. They're physically present in the U.S. on account of trafficking, and the applicant complied with requests for assistance unless they're under the age of 18. Number 4, the applicant would suffer extreme hardship upon removal. And 5, again, the applicant must be admissible or must be eligible for a waiver of that inadmissibility.
So let's pause for a second and delve into this on account of language, because I think that confuses many practitioners. And what is it exactly that needs to be shown in order to prove this element?
Right. So at first glance, it looks like element 2 says the applicant's most recent entry to the United States must have been under the control of the traffickers. It doesn't necessarily mean that, though that's one way to show number 2. It means that they continue to reside here after escaping the trafficking because they haven't had a clear chance to return home, or they have to stay in the United States because of the cooperation that they're giving to law enforcement due to the trafficking. But as we noted in number 2, any exit from the United States after trafficking may affect their T visa eligibility. We have 2 former T visa clients who were rejected because they went home after escaping trafficking using TPS and traveling with permission, but that exit from the United States broke that eligibility under this second element here.
Okay, so let's say you have someone who's already coming to the United States, but they're kidnapped in Mexico, trafficked in Mexico, they escape, and rather than turn around and go back home to Guatemala, they continue on to the U.S. How does that work with the on account of? They're still escaping their traffickers.
I think it's worth an argument. Generally speaking, the cases we've seen, law enforcement is only interested in certifying, and Vermont is only interested in granting cases where trafficking happened in the United States or was investigated by a U.S. Agency. It would be worth an argument.
Okay. All
right, here is the TVPA definition, which I won't read, but I will point out that there is that exception built into the law for persons under the age of 18 involved in sex trafficking. Even if you have a client who, according to her or him, completely willingly engaged in commercial sexual acts for someone, their consent is really irrelevant at this point. Force, fraud, and coercion is not required to qualify them as a victim of trafficking under the TVPA. But this also includes the 2 different kinds of trafficking, both sex and labor trafficking. This statutory language is really interesting here because it says all these recruitment, harboring, all these actions are for the purpose of subjecting someone to involuntary servitude or sex trafficking. What that means is even in cases where the trafficking was stopped before it had a chance to occur, they could still theoretically qualify for a T visa. So we had one client who was able to escape. She was trafficked into the United States, tricked into coming here, but escaped from the cantina before engaging in any commercial sexual activity. She was still able to qualify for a T visa because she was trafficked here, recruited, transported here for the purpose of subjection to this.
One thing I think it's important to point out here is there's no temporal requirement in the sense of the trafficking must have taken place for a certain amount of time. So I think with sex trafficking, it's obvious that even one time is horrible and more than enough in this case. But what about involuntary servitude? Does it have to be they made me sweep one floor one day, or does it have to be for a certain amount of time?
Right. So obviously the length and the nature of victimization can go towards making a stronger case, but you're correct in saying there's no minimum time frame. So if someone was trafficked, we had a trafficking client who was a victim of labor trafficking for only a few weeks, that's certainly enough to qualify them. There's no minimum time frame for this victimization.
Okay, and what about a more common scenario that I think a lot of the service providers see are a person being forced to be a foot guide or carry drugs across the border?
I think in situations with those facts that you would have some waiver issues to deal with, but I still think it meets the definition. They've been recruited, they've been provided, they've been obtained for the purpose of labor services. The statute doesn't require that the activity be legal, just that they were subjected to involuntary servitude, whatever form that took.
Yeah, that's a good point.
All right, so these are the more common offenses we see for minors, but obviously any of the issues we just talked about, there's a whole big section in this area of the code, and it's worth looking into, but these are the more common ones we see for minors. Certifications for T visas generally look a little bit different because most agencies don't have a set policy for signing T visa certifications because they're so relatively rare. For T visas, generally speaking, most of our adult clients haven't yet reported to law enforcement when they come to us for an intake. If that's the case, the attorney should definitely facilitate, especially in the current climate, making that report and accompany the victim to all law enforcement interviews. These are the agencies we generally consider and prefer when making a trafficking report. Most large metropolitan areas, Houston, Dallas, Austin, all have human trafficking task forces with officers who have been specially trained in interviewing victims of trafficking. So obviously that's the place we would want to start, with people who understand what the law is and understand how to interview victims. Barring that, we usually go to a federal agency, to the FBI, to the HSI, or DOL office that's closest to us, depending on the type of trafficking. The Department of Labor does have jurisdiction to sign both U and T visa certifications, so if you do have a minor labor trafficking victim, they're definitely the agency to go to. Local law enforcement agencies can and do certify trafficking cases, but they're generally a lot less familiar with those types of crimes, and they're a lot less understanding and less likely to classify a case as trafficking as they are for regular sexual assault and physical assaults. We found in our experience that agencies often give special consideration to minor victims, meaning they're much more likely to respond quickly, much more likely to interview and certify quickly. So it's definitely worth putting your client, if he or she is comfortable with it, in communication with law enforcement for this purpose.
And Elise, what's your experience with dealing with some of these big agencies? I mean, when you call the FBI and say, hey, I think I have a human trafficking case, how does that really play out?
Well, with the task force, it plays out really well. So generally speaking, we make a report to the task force. They assign an officer. We either take the client to them or they come to our office to interview the client within a week or two. The hardest part is generally getting them to respond.
And that's the Houston Task Force.
The Houston Task Force, exactly.
When it's somebody like HSI or FBI, do they take your report directly? Do you have to FOIA something to give them a little bit of evidence to go on?
No, generally speaking, we let law enforcement do the investigation if they feel it's necessary to corroborate what the victim is testifying about. So I leave that to their discretion and their own investigation. We generally provide the victim and have the victim do everything within his or her power. Anything else is up to them.
Okay.
So when you're working with T visa certifications, remember they're not required like U visa certifications are. They also don't expire after 6 months like U visa certifications do. There's also no authorized and designated certifying official for T visa certifications. So technically any law enforcement officer could sign off on this, but it does require their supervisor's signature on the form as well. Like I said, it is possible to apply without a certification. If you do, address cooperation thoroughly, but we as advocates have a different prerogative than law enforcement does. There's been plenty of times where I've disagreed with law enforcement's assessment, we filed without them, and we've won the case. So my advice would be to err on the side of applying if you believe your client qualifies. And again, if the victim is under 18, they're not required to show cooperation. There's also another exception if cooperation with law enforcement would cause extreme physical or psychological harm to the client. It's another exception we don't generally tend to use, but is available if you feel it's the case.
And that last bullet point there, just for the audience's sake, I want to say reads, ask federal law enforcement agency to obtain continued presence, a deferred action EAD, for the victim.
Right. Only federal law enforcement can obtain that, but and they're generally very reluctant to do the extra paperwork that comes with that, but generally speaking, federal law enforcement can and does get that for victims of human trafficking.
Okay. And this is probably a good point to ask about the difference between trafficking with a T visa and the availability of a U visa based on trafficking, because it's one of the enumerated crimes. So when do you go with which, and can you do both simultaneously?
Right. So generally speaking, we almost always prefer a T visa for several different reasons. First, T visas are much faster than U visas. They are subject to a limit, but they haven't been overwhelmed with cases like the U visa has. Second, T visa certifications aren't required for applications, so we have much more flexibility in filing. And third, people with an approved T visa qualify for public benefits, and they can bring minors in with IOM. So there's a lot of advantages to filing with the T visa. But absolutely, if we get a U visa certification, we'll absolutely apply for a U visa based on trafficking and a T visa at the same time and see which one comes back. The only situation in which I would apply for a U over a T would be if a client left the United States after the trafficking and therefore didn't qualify.
So they broke that chain on account of.
Exactly.
Okay.
So next up, we're going to talk about showing extreme hardship upon removal to home country. And these are the elements that the service will look at, but generally speaking, they're showing hardship based on country conditions on this client's personal circumstances.
Okay.
So for classic T visa derivatives, the same categories of family members as U visa may qualify as T derivatives. So for adults, spouses, and children, for minor victims, spouse, children, siblings, and parents. There is a new change to the regulations, which we actually haven't had an opportunity to use in my program, but they've extended categories of derivatives only for the T visa if these derivatives face a present danger of retaliation because of the principal's trafficking experience or escape. This new category is essentially the adult or minor child of any current T derivative, which means grandchildren, spouses, children, nieces, nephews, and siblings of the principal applicant. So if she had a sibling who was 25 years old, didn't qualify as a classic derivative, could apply under these new regulations if they faced a danger of retaliation. The great thing about T visa derivatives is upon T approval, they can contact the International Office of Migration, who will handle consular processing and pay for the travel costs for the derivatives. And there's no T visa equivalent to the U visa's I-929 for later acquired family members.
And that's that piece where they could ask for consular processing for a derivative, right?
Right. So they can do that for derivatives abroad after the U visa or T visa is approved, excuse me.
Yeah.
So if you're lucky enough to win a T visa, you would get a 4-year employment authorization, non-immigrant status, and the same benefits for derivative family members. The average processing time for a T visa isn't the 2 to 3 years that we see with the U visa. It's a relatively quick 4 to 12 months. And for minors, we usually find they fall on the faster end of that spectrum. For one certified minor victim, we had an approval within 2 months. And again, T non-immigrants are eligible for public benefits once they're identified. So even before the T visa is approved, if I identify a victim of human trafficking, they can qualify for federal benefits and more upon T visa approval. And speaking of, this slide is about social services for survivors of trafficking. Victims of trafficking and trauma obviously have wide-ranging needs. And there are lots of protections and benefits built in for survivors of trafficking. So there are several TVAP programs in Houston, the Trafficking Victims Assistance Programs. For example, in Houston, through Catholic Charities and the YMCA, survivors of trafficking can get intense case management, social services, medical care, public benefits, Medicaid, and federal law enforcement, as we mentioned, can also obtain continued presence for them.
And you mentioned here at the last bullet point the HHS eligibility letter. That's something more on like the casework side, but maybe attorneys need to be kind of aware of just asking for these things or pointing it out to their clients.
Absolutely. So caseworkers, usually when minors are detained in the shelters, the caseworker will request an HHS eligibility letter, which not only benefits the client but can be used as evidence in the T visa application. So it is good to follow up on that and make sure it was done.
And we're going to move into the waivers that are necessary for UNT visas because, and oftentimes you might need a waiver, but you're almost always going to need one for at least the EWI aspect of things.
Absolutely. So this is the area I get the most questions on with pro bonos we work with because these waivers do tend to be different from anything else you may have experienced in immigration law. This is not the I-601. This form for a waiver is the I-192, and under 212D, all grounds of inadmissibility, including EWI, may be waived for UNT applicants. The only enumerated exceptions are Nazi persecution, genocide, torture, etc. So anything else, theoretically, is waivable.
Did you just etc. over extrajudicial killing?
I did.
It's like a yada, yada, yada.
But anything else, theoretically, could be waived through a U or T visa, though obviously the more severe the ground of inadmissibility, the more arguments will need to be made. After the VAWA 2013 reauthorization, there's also no, UNT applicants don't need to worry about the public charge ground of inadmissibility. And we have, through Catholic Charities, we've had lots of things waived. Obviously, one EWI entry is the more common one that we see, and that's, I don't want to say automatic, but the vast majority of people get that approved and waived with no issue. But even for more serious grounds, for felonies, for multiple orders of removal, for multiple EWI entries after orders of removal, whatever the case may be, we've had a lot of different things waived. So this is a very generous waiver available through the UNT visa.
That's really good to know because I think a lot of people are intimidated, especially at the screening stage, when they hear some of these things, especially if you hear about a prior felony or something.
Right.
That's almost always a huge red flag, and it should be, but it's not dispositive.
Right. This is the magical unicorn of waivers in the immigration world, so do take advantage of it. If a client doesn't qualify for anything else, this might be their only potential relief. So here are some of the things that the service is going to look at when they're deciding on a waiver. They break it into two big categories to show the waiver is in public and national policy interests and showing a balance of equities. So the AG's discretion can be used even in serious cases. The most practical piece of advice I can give you is to tie these grounds of inadmissibility back to the client's victimization. So one thing we see all the time, for example, is a client has a DWI after they suffered domestic violence or a sexual assault. The way to tie that back is to tie it back to what they suffered and what was going through their minds at that time. If they developed an alcohol problem because of the abuse that they suffered, because they were self-medicating, that's an important argument to make. They have told us that they're looking for applicants to take responsibility for prior grounds of inadmissibility and show rehabilitation. And we, on the next slide, I believe, look at a couple of different things. But for criminal immigration and immigration violations that are a little more serious, they're looking at risk of harm and their reasons for wanting to enter the United States. For the most serious criminal activity, for ones that are violent, they're looking for exceptional or extremely unusual hardship, similar to cancellation. So it really is a balancing act that they do. Depending on the severity of the crime, you're going to need more equities in the United States.
Okay. And on that documentation for getting these waivers?
So the documentation you'll need varies, again, on the severity of the ground of inadmissibility. So for very simple criminal activity, for traffic tickets, petty offenses, or just one EWI entry, you might not need any additional documentation other than the answers you're giving in the I-918. For any other criminal grounds, we can include arrest or court records, the client's explanation of what happened and any mitigating factors, and then the applicable law for here in Texas. And for any immigration grounds, any documentation they have. Most of the time, my clients don't have anything, so we just include an explanation of the circumstances behind that.
And with these prior criminal activity, I guess, this is bringing up the idea in my mind from the U visas per viso of the victim not being culpable in the criminal activity. Have you ever had to kind of parse out the criminal activity that might be on your client's record with the actual crime that the U visa is based on, kind of thing, and try to explain that to USCIS?
I mean, generally speaking, no. It's usually clear from our answers and from the documents we submit by the dates on those that those are two separate incidents. However, we do run into difficulties when the client's criminal history includes crimes that are themselves qualifying crimes for the U visa. So if, for example, I'm applying for a derivative husband who has a history of family violence, we're going to be definitely RFE'd on that because USCIS is going to want to know why they should benefit, even though they themselves have committed the kinds of crimes that are the basis of the U visa that we're applying for. In that case, we really do have to hit hard proof of rehabilitation and mitigating factors. So we go back to that balance of the equities. Especially the longer ago it was, the more rehabilitation we can show, the stronger the waiver is going to be.
And it's fair to say that those equities are, and really the whole process is about the same as you would do for an I-601 waiver, showing equities and rehabilitation.
Absolutely.
Okay. So some special issues and practical steps. I'm going to give Elise a break here and just want to talk about kind of how you go about this in the screening process. And this is something I said at the outset that we wanted people to focus on. So your screening, you want to pay particular attention to the details, obviously, as you always would, but have they been a victim of the crime or has a family member been a victim? And like I mentioned before, we often ask a child in screening, have you been a victim of a crime? Have your mom? Well, they're probably not going to know that. And in a lot of cases, I would anticipate parents not having told their minor children that they were crime victims, right? Especially if it was a sexual assault or something. So it might be worth, if you kind of think that there might be something there, talking to the parent if obviously you have that rapport and ability to do so. Has the crime been reported? To which agencies? Did the client cooperate? And remember, there doesn't have to be prosecution of the crime. It just has to be helpful in the investigation. So the cooperation doesn't have to go all the way through to testifying at trial. It doesn't have to be that involved. And what other potential family members can be included? So you got your age-out deadlines for derivative family members potentially. Who could you request these certifications from? So which agencies might? And like Elise was saying, you can kind of think outside the box. If the crime happened and down on the border, you don't have to only go to the, I don't know, the Brownsville Police Department or something. You know, you're looking at HSI, you're looking at the FBI and many other, you know, possible things, and task force. You know, these are things that we don't necessarily think of off the bat. And then what other needs do the clients have? And I think that's really important because we get so caught up in the legal side of things that, you know, I'm not going to say we forget. We're all in this business to help the clients, and I think all of the lawyers working in the VERA network and everywhere else know to look out for these social services needs of the clients. But apart from the counseling and protective orders, Elise, what is these acronyms here, VINE and CVC?
Right. So if you haven't worked with crime victims here in Texas extensively, you might not know them, but VINE is the Victim Identification Network for crimes that occurred in Texas. So if your client is a victim of sexual assault, for example, they can register through this system and be notified anytime any action is taken with the perpetrator of that crime. Every time he goes up for a court hearing, if he's up for parole, if he's released from jail, which is not only helpful to their peace of mind, but also as a safety consideration. So we encourage clients to enroll in that system. CVC stands for Crime Victims Compensation. If a victim of a crime that occurred here in Texas incurred costs because of that crime, medical costs, counseling costs, relocation costs, they can apply to the state of Texas, the Attorney General's office, to recoup those losses.
Okay. So the gathering documentation side of this looks about like you would expect for gathering documentation on an asylum claim or almost anything. And you're going to get all the basic information. You're going to want counselor, therapist, maybe psych evals essentially. Especially if you're going based on the emotional abuse or something.
Absolutely.
The documentation of homelessness, how does that look in reality? How do you document homelessness?
Right. So generally we see that when clients have been forced to move to a shelter, shelters can give a letter that's actually called documentation of homelessness. If they're homeless and living on the street, they'll often go to different nonprofits to seek supplies, to go get a shower, and those agencies can also provide a letter of support.
Okay. And everything else here, again, is fairly straightforward. You mentioned that crime victims compensation application from the CVC thing a second ago. So all of those, the applications, all the paperwork that goes into every part of this process can be used in your application later too, not just for that particular assistance.
Absolutely. Anything that came out of the crime, medical records, if they missed school or missed work, anything that goes to show they suffered or they suffered a crime, then it's worth including in the application.
Okay. And I see that we have a question here. If the U visa crime happened a few years ago, should you still send them to counseling?
Absolutely. So not only is it possible, if not probable, that they are still suffering psychological injury because of that trauma, it's always worthwhile sending them just to be safe for their own psychological purposes, because you will be going back into a lot of the details of that victimization, and you don't want to risk re-traumatizing them, especially for younger victims. Also, on the practical side, you can use a letter of support from that counselor to shore up the requirements for the U visa, that they can provide a letter documenting the physical or mental harm suffered by the client.
Okay. And here's the info for reference later of the logistics of filing either a U or T application. We're not going to need to go over it here in the webinar. It's here for your reference later. And of course, available on the USCIS website. So for victims currently in removal proceedings, and we've got these bullet points here, and I think a lot of this is pretty common sense with what you want to do, but I want to ask you a few questions while the audience is looking at these aspects here on the bullet points. The EOIR practice manual points out that hearings involving an abused alien child are closed to the public. It doesn't say necessarily how to go about that. So how does that work in reality?
My understanding is that oral motions for that are usually sufficient. So especially if you can give them notice at the master calendar that for an individual hearing where these details are going to come out, that you'd like a closed hearing, that they can usually accommodate those requests.
Okay. And this whole aspect of all these bullet points go to an overarching question I wanted to ask you, and that's, are there risks in filing for someone who's not been NTA'd? So this is about victims currently in proceedings, but someone who's not yet gotten NTA'd.
Right. So with any contact with USCIS, there's obviously some amount of risk. In the past, our understanding is that the risks associated with filing with the Vermont Service Center are relatively minimal, that their policy has been that just because an application is denied on the merits, and that's the only reason that they don't qualify, that they won't go to the lengths of issuing an NTA following denial. That always can change in the future, so it is something important to discuss with the client so they can make an informed decision on that risk. But generally speaking, we have not seen any case that was denied referred for prosecution.
Okay.
Or for an NTA, excuse me.
And down here at the bottom, the last bullet point is about each judge or TA being a little bit different on whether they'll agree to continuances or admin closures. And I guess it's probably more of an issue with your conditional U approvals, right? How does that work maybe in Houston where you're practicing?
Right. In Houston, we haven't actually seen how conditional approvals are going to affect how this plays out in court because the conditional approval process is still relatively new. What it really is what it says on the slide here, that each judge and each TA is very different. In my experience, judges don't want a case just filed. They usually are much more comfortable terminating, obviously, once a case has been approved. But we have been successful in getting really lengthy continuances and administrative closure while the case is pending. But they do want to see receipts. Generally speaking, a certification and a victim being certified isn't enough.
Okay. And do they want a copy of the application? And I think we're a little bit cut off on the bottom of the screen there, but there is a case in re Sanchez Sosa, and I'm pretty sure that case came back saying that the judge was entitled to ask for a copy of the actual application.
Exactly, which we learned the hard way once and won't make the mistake again. So generally speaking, we come only ready with the receipts in the hopes of protecting all that very confidential information, but if the judge does persist, we do have copies of the applications ready. We don't generally send client statements, any other documentation, but all of the CIS forms we will.
Okay, so it is something you should be prepared to provide if asked for.
Correct.
All right. And victims with prior orders. So do you want to take it?
Sure, I don't mind at all. So again, before UNT approval, you're still working with that potential danger of them being removed at any time, especially in the current climate. After approval, they're eligible to seek to reopen and terminate that case. For T visas, final orders of removal are canceled by operation of law on the date of the T approval, so it's not actually necessary. Generally speaking, the Vermont Service Center goes back and forth, but now their policy is that they retain exclusive jurisdiction, that they can grant adjustment based on youth status even if there is an unexecuted removal order outstanding, which means I have clients now who are legal permanent residents that still have an outstanding order of removal that needs to be taken care of.
Okay. And I'm assuming you have to contact OCC for that. And how are they, I guess the local OCC at least, how are they in terms of amenability to those motions to reopen and terminate?
They have gone and said that they are on board with reopening and terminating, especially after the grant of LPR status, but getting them to respond is a whole other issue, so we generally wait for a response and then go ahead and file on our own.
Okay. Moving along, special considerations to working with minors. I'm not going to belabor these points too much because I know that most of our audience, or if not all, work extensively with minors, and these are the same kind of considerations you'd take into account when doing your screenings and representing minors in any situation, really. So I do want to ask about the last point here, the last bullet point about safety and confidentiality of the victim. And these are things that we all take into account with our obligations as attorneys, but are there special considerations for these types of cases, for these crime victim cases, that we should be cognizant of?
The only other special consideration I would bring up, especially with confidentiality, is to be careful when you're doing your initial questioning to even determine if they are crime victims. Statistically speaking, with minors, perpetrators are usually family members. So even if the perpetrator isn't in the room with them, that person could then relay information back to the perpetrator in the family. So you never know what you're risking by questioning them in front of other family members, and to be cognizant of that risk.
Very good point. And we're going to move into VAWA really quickly here. I don't want you to forget about VAWA because it is something that could provide relief for your clients, and even VAWA cancellation of removal, which can work if the child is now over 21. So keep these in mind. The form is the one you're all familiar with, the I-360. So the VAWA requirements, I think, are well known, and that allows a battered spouse, child, or parent of an abusive U.S. citizen or LPR to self-petition, right? So children can be direct petitioners or a derivative of a parent's petition, but we're going to talk about children as self-petitioners here particularly. Unmarried and under 21, we know, but there's that asterisk there, and that's if they are eligible at 21, they can file up to the age of 25 if the abuse was a central reason for the delay, right? Then you've got your abuser is the USC or LPR parent, and I've got parent in quotes there because this could take many forms and maybe not the one that we're traditionally always looking for. So you've got your children born in wedlock, and you've also got the idea of a common law marriage that could have been in place, and that might be very much more common with the different populations that you're working with. There's the out of wedlock if the child is legitimated or acknowledged by the father. I know all of the SIJ attorneys are very familiar with these acknowledgments of paternity these days and different ways that can happen. There's stepchildren as well, so look out for those step parents that might be involved in the picture or maybe were involved at some point in the picture. Again, things that maybe a child who's been in home country for the last 15 years isn't even aware of, that mom had a common law husband for 5 of those years or something, right? And now he's gone already, but there was something going on that might qualify her for VAWA. So, and adopted children. And those are, the adopted rules have a lot of different kind of ins and outs, so I encourage you to definitely reach out or do a lot more research when there's an adoption involved. The child was subjected to extreme battery or cruelty and residing in the U.S., although the child doesn't necessarily have to be in the U.S. anymore as long as they were previously subjected to it, and lives or lived with the abusive parent. Finally, the good moral character. And on the good moral character issue, it's important to note that we're used to the juvenile delinquency not counting for AOS purposes, but it can be taken into account by USCIS for this good moral character provision for children who are 14 plus. Can you add to that a little bit, Elise?
Sure. So it is for any applicants 14 years of age or older, but it also does only look at the past 3 years. So if you've got an 18-year-old who had a juvenile delinquency offense at 13, that might not be included in that spectrum of the good moral character that they're looking at.
Okay. But it is something that we can't just dismiss outright and say, oh, juvenile delinquency, don't worry about that.
Right. You do still need to worry about it both at this VAWA stage and potentially even at the adjustment through VAWA stage.
Okay. And we have here a very rudimentary chart that, at least when I was trying to play this out in my mind as to which way you go with all of these different possibilities, you've got a lot of overlap here. You know, with your abuse could be U or VAWA, trafficking could be U or T. What are some of the very, very basic considerations you want to look at, right? So with the VAWA, is the abuser a USC or LPR parent, right?
Right. That's the fastest way to screen out for VAWA is to determine who the abuser was and then determine if they had status. If no, you immediately move on to a U visa. With the T visa, it works the same. Do you have a trafficking offense? If yes, then you've got two options in front of you, and then it really comes down to the certification. But the bottom line is that we work with vulnerable populations who often have multiple instances of victimization. The more they qualify, the better. So if they qualify for all three, submit all three.
Okay. And that's really all we wanted to go into on the substantive slides here. I did have one final question for you about how do you decide which one of these various things to pursue, or better put, how do you explain the nuances to your clients in order for them to make an informed decision?
I actually explain it in a lot of the way you put it on that slide. Is each one is its own box and is based on different things. So if I, for example, in my VAWA spouse cases, feel like we're going to have a hard time showing common law marriage, if they live together only for a short amount of time, for example, I explain that that VAWA is based on that marriage and residency, and it is difficult to prove. With U visas, it's based on law enforcement certification. So once they understand the basis for each of these forms of relief, it becomes a little bit easier to pursue the one that they're most eligible for. But at the end of the day, we can only explain to the client and let them make the informed decision.
Okay. And as I was saying, that's all we have on our substantive slides, and we do have some questions in the chat box that I want to get to. Here's some further reading and technical assistance kind of places you can go, and you can always reach out to us at CILA or Elise as well, and we'll try to help you where we can. Don't overload Elise with questions. You can come to us if you want, and then we'll reach out to her if that's better. But the question we had from our chat box is, let me pull this up here, and please feel free to write some more. If you have any further questions, please put them in the chat box now, and we'll try to get to them. We have a few minutes here. If a minor, 15 years old, was in the middle of stepdad's physically abusing the minor's LPR mom, could the minor be considered as a direct victim or possibly indirect? The minor was the one who called the police to help save mom, but once the police arrived, mom was cooperative.
So my answer is yes. So either or maybe both. So it all depends really at that point. We understand the law, but it all depends on what you can get from the certifying agency. So if they're not familiar with the intricacies of indirect victims, for example, you might not be able to get a certification saying they're an indirect victim. But regardless, try for a certification and see what happens. And your argument is exactly that the minor is the one who called the police. You also didn't mention in your question if the abuser had status in the United States. If they did, they were an LPR or USC, the minor might also qualify as a VAWA self-petitioner.
Okay. And for a stepchild VAWA self-petition, do the parent and step-parent have to still be married when VAWA is filed?
That's a really great question, and I'm not sure I know the answer. For VAWAs, for self-petitioners that are abused spouses, there's protections after divorce. For 2 years following the date of divorce, a VAWA self-petitioner can file the petition. So I imagine that same thing would hold true for stepchildren, but I actually haven't ever looked up that specific question.
And I would think, too, it's always really good to delve a little bit deeper into is there a divorce, right? Because just because they're not living together anymore doesn't mean that they're not still married. And so there's always that aspect. And another question we have is, let's see, the most legal arguing for U visas like a crime being substantially similar or suffering the required abuse done in the form of responding to an RFE, or do you do it in the cover letter?
I would say my own current, my policy is I wait for them to RFE me on it. I'm never going to volunteer that my crime isn't exactly a qualifying crime. So the way I'll usually handle it is if I get a certification that says aggravated robbery, I submit it and I wait for them to call me out on it. Usually I can get by with no request for evidence. If they do happen to respond and request that information, I'm prepared to argue it. But yeah, let them call you out on it. Don't do their work for them.
I like your style. For VAWA, what is the statute of limitation?
Statute of limitation, there isn't one as far as I'm aware. So there are different deadlines for filing based on the status of the marriage. If the abuser loses LPR status because of the abuse or otherwise, you have 2 years to submit the application. But generally, and after divorce, there's a 2-year deadline as well, including separation from common law spouse. But other than that, there's no statute of limitation I'm aware of.
Okay. And I'll give people maybe another 30 seconds to put any questions they have in there, but I want to thank you, Elise, for being here today.
Great, no problem.
Your
Happy to be here.
expertise is invaluable to us, and we really do want to encourage the legal service providers to look more at these options when they are doing their initial intakes and throughout the whole process, because as I said at the outset, with SIJ and other forms of relief being more involved, I will say, under the current climate, that we need to explore every single option to provide the best possible legal assistance to our clients. With that said, once again, thank you for joining us today, and I hope this was as fun for you as it was for me.
It was.
Our listeners are probably familiar with NPR a little bit. I'm guessing that nonprofit attorneys might be fans for the most part, so I'm going for my best Terry Gross or Ira Glass today. But I hope we were able to impart some good information, and please reach out to us at CILA. We will be sending these slides out in PDF to all of the participants, and the audio recording will be available on our website within, give us a week or so. And thank you all for joining us.
Thank you, everyone.